This is the brief on the Philippine Anti-Wiretapping Act. Republic Act 4200 fiercely protects private conversations from secret recording, but its decades-old technical definitions have created surprising legal loopholes in the modern digital age. First, the core rule. It's totally illegal to secretly record, intercept, or overhear a private communication without everyone's consent. And yeah, this applies even if you're a participant. Public speeches don't count, because they aren't private. Think of a private chat kind of like a joint bank account. Even if your name's on it, you can't secretly withdraw the funds, or the recording, without the other person's explicit sign-off. Second, the technology loopholes. The Supreme Court ruled this law specifically targets the physical tapping of a main telephone line or using specific spy devices. So wait, does this mean modern internet calls just get a free pass? Well, yeah, because Skype isn't a traditional main line. Listening on an ordinary extension phone, recording a Skype video call, or accidentally overhearing a crossed line doesn't violate this specific law. Finally, the law enforcement exception. Peace officers can legally wiretap, but they face massive hurdles. Can the police just yell national security and start listening? Absolutely not. Officers need a written court order, granted only for severe crimes like treason, rebellion, or kidnapping, expiring after a maximum of 60 days. Plus, they must literally prove to a judge wiretapping is the only possible way to get the essential evidence. Ultimately, while the law requires absolute consent for recording traditional private chats, its rigid, outdated focus on physical wires leaves massive blind spots in today's digital world.
You ever been in a conversation, a really important one, or maybe a totally outrageous one, and just thought to yourself, man, I wish I was recording this? It's a tempting idea for sure, but hitting that record button, well, that opens up a whole can of legal worms. Today, we're going to dig deep into the law and figure out when, if ever, you can actually do that. So let's just get right to it. Is it illegal to record someone without their permission here in the Philippines? Now, you'd think the answer would be a simple yes or no, but honestly, it's so much more interesting than that. The real answer depends on the kind of tech you're using, the specific situation you're in, and how the courts have tried to make sense of a law that was written all the way back in 1965. All right, here's our game plan. We're going to start with the main law itself. Then, we're going to try to solve 3 real-life legal puzzles that made it all the way to the Supreme Court. We're talking about everything from old-school extension phones to modern-day Skype calls. Each case gives us a new piece of the puzzle, and by the end of this, you'll see the whole picture a lot more clearly. To get to the bottom of our big question, we first have to look at the one law that's at the center of all this. And this is it, Republic Act 4200, also known as the Anti-Wiretapping Act. Now, remember, this was passed back in 1965, but its main idea is pretty straightforward. It is illegal for any person to secretly record a private chat without getting permission from all the people in that conversation. And that word all, trust me, that is the absolute key here. It's at the very heart of every single case we're about to look at. So our first stop is in 1986. This case really pushes the boundaries of what the law considers a recording device. This is the case of Garion versus the Intermediate Appellate Court, and believe it or not, it all comes down to a humble extension phone. Okay, so here's what went down. A lawyer calls this guy Laconico, supposedly trying to get some money out of him. Laconico gets nervous, so he tells his own lawyer, Gannon, hey, can you pick up the extension phone and just listen to this? Gannon does. He hears the whole thing, and then he uses that information in a legal complaint. So what does the first lawyer do? He turns right around and sues Gannon for illegal wiretapping. So let's break this down. You have a third party, Gannon, who secretly listened in on a private call using a device, an extension phone, without the okay from both people on the line. I mean, based on the law we just read, this seems like a total slam dunk, right? It's got to be illegal, doesn't it? And the Supreme Court said, nope, it was not illegal. I know, that's pretty surprising. It feels like it goes completely against what the law says. So we have to wonder, what on earth was the court thinking? How could listening in on an extension phone be perfectly fine? Well, the court's reasoning was actually pretty clever. They looked at the kinds of devices the law was written about, things like dictaphones and tape recorders, and said, okay, those are tools made specifically for secretly recording people. But an extension phone? They argued that's just a common piece of office equipment. When you make a phone call, there's always a chance someone could be listening on an extension. It's sort of a known risk, and it's not the same as a hidden tapping device. All right, let's jump to our next puzzle. We're now in 1995, in the case of Ramirez versus the Court of Appeals. The technology is a little different here. And importantly, the person doing the recording is actually in the conversation. So the story here is pretty simple. An employee, a woman named Socorro Ramirez, gets into this really heated argument with her boss. She feels like she's being treated unfairly, so she secretly hits record on a tape recorder and captures the whole thing. Later, she tries to use a transcript of that recording to sue him. Well, her boss flips the script and files a criminal complaint against her for violating the Anti-Wiretapping Act. So this adds a totally new wrinkle, right? The person hitting record is actually part of the conversation. Does that make a difference? You might think the law is just for outside eavesdroppers, but remember the wording. It prohibits any person from recording without consent from all parties. So what do you think? Did the court say this was okay? The Supreme Court came back with a hard no. It was completely illegal. Even though she was in the conversation, the act of secretly recording it was still a crime. And this sets up a really fascinating clash with that extension phone case. So let's just recap for a second, because this is where it gets wild. In the first case, a third party secretly listening on an extension phone was found to be totally legal. But in this case, a participant recording her very own conversation with a tape recorder, that was illegal. So what gives? Why the huge difference? Well, it all comes down to the specific device she used and what the people who wrote the law were worried about way back in 1965. See, the reason goes back to the original debates in the Senate when they were writing this law. One of the authors, Senator Tanyata, basically said that secretly recording someone just isn't sporting. It's not fair. The law he helped write specifically lists a tape recorder as a forbidden device. So the court's conclusion was simple. It doesn't matter if you're in the conversation. If you use one of those forbidden devices to secretly record someone, you've broken the law, period. Okay, now let's fast forward to right now. We've talked about extension phones and tape recorders, pretty old school stuff. But what happens when the conversation isn't happening on a physical phone line at all? What happens when it's happening over the internet? In a case from 2023, a police officer went undercover online to investigate a human trafficking suspect. He started talking to the suspect on Skype, having video calls and everything, and he recorded those calls as part of the sting operation. After the suspect was arrested, his defense team made a bold argument. They said all those Skype recordings were illegal evidence because they violated the Anti-Wiretapping Act. And that brings us to our final and maybe most important puzzle. You've got this law from 1965, written for tapping physical wires and using clunky analog devices. How in the world does that law apply to a video call happening on the internet? Is recording a Skype call really the same thing as tapping a phone line? And the court said the recordings were perfectly fine. They were admissible. Now, their reasoning got super technical and focused entirely on the exact words of that 1965 law. The law says it's illegal to tap a wire or cable. The court reasoned that an internet call doesn't travel through one single physical wire that you can tap in the old-fashioned sense. So they found that this specific act of recording a Skype call actually fell outside the scope of the old law. It's a very literal, by-the-book reading, and it just goes to show you how much our technology has outpaced our laws. So, wow, after that whole journey through 3 very different cases, what's the big takeaway here? Let's try to put all these pieces together and see what clear rules we can actually walk away with. This table really puts it all in perspective. The extension phone, that was legal because it's a common tool, not some specialized spy gadget. The tape recorder, totally illegal because the law specifically calls out that technology for secret recording, and it doesn't matter if you're in the conversation. And the Skype call, the recording was allowed in court because technically it didn't fit the 1965 definition of wiretapping. So if you're going to remember anything from all this, let it be these 4 things. 1, the basic rule is you need everyone's permission, all parties. 2, the court really cares about the device you use. Is it an everyday thing or is it made for spying? 3, just because you're in the conversation, it does not give you a free pass to secretly record it. And finally, 4, as a Skype case proved, this is all still changing. The law is trying to play catch up with technology. And that leaves us with one last huge question. We've seen this 1965 law get stretched to cover extension phones, tape recorders, and even Skype. But as our private lives and conversations move on to platforms we haven't even really wrapped our heads around yet, with AI assistants that are always listening, smart devices all over our homes, the metaverse, how are the courts of the future going to decide what counts as a device or an illegal tap? Now that's something to think about.
Imagine your smartphone right now. Just, picture it sitting there in your hand, or maybe it's resting on the desk in front of you.
Right. Everyone has one within arm's reach.
Exactly. And I really want you to think about what that device actually is. Because, it's definitely not just a phone anymore. It is this highly encrypted, densely packed digital vault.
Oh, absolutely. It's essentially your whole life in there.
Yeah. Think about what you keep inside it. It holds your most private, unfiltered group chats. It holds those voice notes you sent in moments of vulnerability.
Your banking details, the location data from the last 5 years.
Right. And let's be honest, photos you probably wouldn't want plastered on a billboard. Everything that makes up the intricate, messy reality of your modern life it's locked inside that little glowing rectangle of glass and metal.
It really is the ultimate repository of our personal lives.
Yeah.
We trust that piece of hardware with secrets, anxieties, conversations that we wouldn't dare share with our closest friends. Or even family members, It's essentially an external hard drive for the human brain at this point.
That is the perfect way to describe it. Now, I want you to imagine trying to protect that incredibly complex, modern digital vault using a rusty padlock and a set of instructions written in 1965.
Wow. Yeah, that is quite the mental image.
Think about it. 1965, we are talking about an era of rotary phones where you had to physically spin a dial.
Oh yeah, the heavy plastic ones.
Exactly. An era of heavy, clunky analog dictaphones that used actual magnetic tape. Walkie-talkies with giant telescoping antennas.
Right, the kind of stuff you see in old spy movies.
Yeah, and that is the technological universe we are pulling our security rules from to protect an iPhone. You have 21st century technology capable of global instant transmission, and it's just colliding head-on with mid-20th century legal frameworks that were, deeply paranoid about hidden microphones and flower pots.
The contrast is staggering when you lay it out like that. And it's not just a theoretical mismatch either. This collision creates real-world legal chaos. The way the courts have been forced to stretch and bend and interpret words written decades ago just to apply to situations the original lawmakers could never have possibly dreamed of, it is a masterclass in legal evolution.
And today we are unpacking the Philippine Anti-Wiretapping Act and figuring out exactly where the legal tripwires are hidden right there in your phone.
There are quite a few of them.
Because we are exploring the fascinating, sometimes completely bizarre and constantly evolving world of privacy, recording, and communication laws, we are going to look at Republic Act number 4200 and see what happens when it goes up against Skype, Facebook Messenger, and digital entrapment operations.
It's a wild ride.
It really is. By the end of this deep dive into the source material, you are going to know exactly when hitting that little red record button on your screen is a brilliant, legally sound move to protect yourself.
And when it might accidentally land you a 6-year prison sentence.
Right. Which is terrifying.
The line between being a savvy citizen protecting your rights and becoming a convicted felon is shockingly thin in this area of law. It often comes down to the literal definition of a single word written 60 years ago.
Okay, let's unpack this. Starting with the very foundation, we really need to go back to the analog roots to understand why the rules are the way they are today. We have to step into the time machine and head back to the Cold War era.
Exactly. To understand the present, we really must understand the specific, rigid wording of the past. The absolute foundation of everything we're discussing today is Republic Act number 4200.
Officially known as the Anti-Wiretapping Act of 1965.
That's the one.
Let's set the stage for 1965 for a second. The world is tense. It's the height of the Cold War. Espionage is this massive global concern. James Bond movies are defining the cultural anxiety around surveillance.
Hidden bugs, wiretapped embassies, miniature cameras.
Yes, all of that. And in that environment, the Philippine legislature decides they need to draw a hard line in the sand regarding privacy. So what exactly does this law decree?
Well, the core rule of RA 4200 is remarkably strict. And it leaves very, very little room for interpretation. It formally declares that it is completely unlawful for any person to tap any wire or cable, or by using any other device or arrangement to secretly overhear, intercept, or record any private communication. And the law is very specific about the gadgets it fears.
Oh, I'm sure.
It explicitly lists dictaphones, dictagraphs, detectaphones, walkie-talkies, and tape recorders.
It sounds like a catalog of spy gear from a vintage magazine.
It really does. But the absolute most crucial part of this law, the mechanism that trips up so much people even today, is the exception clause. The law states that recording is unlawful unless it is authorized by all parties to any private communication.
Wait, hold on. All parties.
All.
So if there are 5 people in a room and 4 say yes, but 1 says no, the recording is illegal.
Unanimous consent is required, yes. Yeah. And this is where Philippine law takes a very distinct, heavily guarded path compared to, some other jurisdictions globally. If you consume a lot of international media or listen to true crime stories from other countries, you might be familiar with the concept of a one-party consent rule.
Yeah, where just the person recording has to agree.
Exactly. In those places, as long as one person in the conversation, which can be you, the person hitting record consents, it's legal. But under RA 4200, every single person whose voice is being captured must explicitly authorize the recording.
Wow. I want to bring this into a real human situation because reading the text of a 1960s law is one thing, but seeing it ruin someone's life is another.
Definitely.
In 1995, there was a dispute that blew up all the way to the Supreme Court. It's the case of Socorro Ramirez v. Court of Appeals. And this case, perfectly and honestly, somewhat tragically, illustrates how rigid this all-parties rule really is. Let's paint the scene.
It is arguably the most referenced case when discussing the strictness of this law.
So it's the mid-90s. We have Socorro Ramirez. She is called into the private office of a woman named Esther Garcia. And from the second the door closes and Ramirez steps in, Garcia just unleashes an absolute barrage of verbal abuse.
Total hostility.
According to the verbatim transcripts from the case files, Garcia is practically foaming at the mouth. She is attacking Ramirez's intelligence, her character, her background. The insults are deeply personal and aggressive.
Yeah, the specifics are pretty intense.
She yells bastoska, meaning you are rude or disrespectful. She screams wala kang utak, meaning you have no brains. She even escalates to heavy profanity, cursing at her with putangina. It is not just a reprimand. It is a hostile, humiliating, deeply traumatic tirade.
It is a textbook example of a highly abusive power dynamic playing out behind closed doors. And, in a private office setting, it is usually just one person's word against another's.
Right. And Ramirez, either anticipating that this meeting was going to go terribly wrong or reacting in the moment to protect herself, has a small tape recorder.
She was prepared.
She was. She secretly records the entire confrontation. She captures every insult, every curse word, the tone of voice, the sheer malice of the attack. And her goal is completely understandable to anyone listening. She wants to use this tape to sue Garcia for civil damages. She wants tangible, undeniable proof of the humiliation and verbal assault she'd just suffered.
From a purely logical standpoint, it seems like a perfectly rational protective measure.
Yeah.
I mean, you are trapped in a room being abused. You secure the evidence so you aren't gaslit later.
But the outcome of this case is a massive shock to the system. Even though Ramirez was a direct participant in the conversation.
She was right there.
Yeah, she wasn't a spy, she wasn't a third party, and even though she was the undeniable victim of the verbal assault, the act of secretly recording her own conversation without Garcia's consent was deemed a criminal violation of the Anti-Wiretapping Act.
Yep. The Supreme Court ruled definitively against Ramirez. By hitting record to document her abuser, she transformed herself into a criminal under the eyes of the 1965 statute.
That is just... I have to use an analogy to understand this because it defies basic human instinct for self-preservation.
Go for it.
It's like a vampire that cannot enter the house unless every single person inside invites it. Or like a nuclear launch protocol. It doesn't matter if you're the 5-star general who built the silo and you're trying to stop a rogue launch. If every single person in that bunker doesn't turn their key at the exact same millisecond, the system locks you out.
That's a good way to look at it.
The law demands absolute unanimous participation, regardless of who is right or wrong. And I really have to push back on the ethics of this. Wait, if someone is actively threatening my life or brutally insulting me behind closed doors, the law says I become a criminal for documenting my own abuse.
I completely understand the frustration. It feels incredibly counterintuitive to modern sensibilities where, documenting wrongdoing is often seen as a moral imperative.
Excellent.
But if we look at the strict literal interpretation of the law, which is the fundamental mechanism the Supreme Court applied here, the rationale becomes structurally clear, even if the human outcome feels deeply unjust.
How so?
The text of RA 4200 explicitly states it is unlawful for any person to secretly record without the consent of all parties. The law makes absolutely no distinction between a participant in the conversation and an outside third-party eavesdropper.
So, to the law, Socorro Ramirez holding the tape recorder in her pocket is legally indistinguishable from a corporate spy planting a bug under the desk.
Exactly. The law is completely blind to the identity or the motive of the person holding the microphone. It purely protects the concept of the privacy of communication.
Wow.
The legislative intent back in the 60s was to ensure that when two people speak privately, they can trust with absolute certainty that their words are not being permanently captured, frozen in time, and potentially used against them later without their knowledge.
Even if they're saying horrible things.
Yes. The law doesn't make exceptions for victims recording their abusers, because textually there is no victim exception written into the statute. The phrase any person means exactly that. Any person.
It is a remarkably rigid shield. It elevates the abstract concept of conversational privacy way above the immediate physical or emotional safety of one of the participants. A participant who might desperately need that evidence to prove they were wronged.
That is precisely the trade-off the lawmakers made in 1965. They prioritized the sanctity of unrecorded speech over the utility of recorded evidence. And to add to the severity of this trap, the law doesn't just punish the physical act of hitting the record button.
It doesn't.
No, it creates a whole ecosystem of liability.
Yeah.
Under RA 4200, it is also a crime to knowingly possess that illegal tape. It is a crime to replay it for anyone else, even your own lawyer.
Are you serious?
I am. It is a crime to communicate its contents verbally or in writing, or to hand out typed transcripts of it.
Let me get this straight. If I am in an office and a coworker secretly records our boss saying something illegal, and that coworker hands me the tape, merely putting that tape in my pocket makes me a criminal.
If you know it was obtained illegally, without all parties consenting, yes. Possessing, sharing, or replaying an illegally obtained recording is penalized just as harshly as making the recording itself.
That's wild.
The law attempts to completely quarantine the illegal evidence, treating it like a radioactive material that contaminates anyone who touches it. And the penalty is not a slap on the wrist. We are talking about mandatory imprisonment for not less than 6 months and up to 6 years.
6 years in prison for recording someone screaming at you. That is a heavy, sobering realization for anyone who has ever thought about covertly recording a hostile boss, a threatening neighbor, or a corrupt official.
It really is.
You essentially have to say, excuse me, before you continue threatening to ruin my life, do I have your authorization to record this for my upcoming lawsuit? Which obviously they will never give.
It creates a tremendous legal bind. It forces people to rely entirely on human memory and eyewitness testimony, which we know from decades of psychological research is notoriously unreliable. But again, it underscores how highly the 1965 legislature valued the absolute sanctity of private speech.
Okay, so we have established that RA 4200 is an incredibly strict, literalist piece of legislation when it comes to tape recorders and dictaphones. It traps anyone who doesn't get unanimous consent, turning victims into criminals.
Precisely.
But this raises a massive logical question. If the law is so incredibly uncompromising about these specific recording devices, how does it handle other, perhaps more common ways of listening in? Which brings us to a fascinating turn in the legal history. Let's look at the analog loopholes. Let's talk about extension cords.
Yes. This is where the strict literalism of the law begins to cut both ways. It's a fascinating study in statutory mechanics. If the Supreme Court insists that the law must be applied exactly as written to convict someone like Ramirez, it logically follows that the law must also be applied exactly as written when defining what devices are actually prohibited.
Right.
You can't be a literalist only when it suits the prosecution.
Let me transport you to Cebu City. The year is 1975. The case is Edgardo A. Ganon v. Intermediate Appellate Court. And this isn't a case of office insults. This is a story of a brazen extortion plot, a tense sting operation, and a brilliant technical legal defense.
The factual background here plays out like a classic crime procedural.
It really does. So we have a complainant, attorney Tito Pintor. Pintor has a client who is currently facing a direct assault charge. The person who filed that assault charge is another lawyer, attorney Leonardo Laconico.
Okay, 2 lawyers.
Right. Pintor approaches Laconico with a proposition to negotiate dropping the assault charge against his client. But this isn't a normal, professional, legal negotiation. It quickly devolves into an overt extortion plot.
Pintor isn't asking for a standard settlement. He is essentially demanding a ransom to make the criminal charge disappear.
Exactly. Pintor demands a total of 8,000 pesos. Now, in 1975, 8,000 pesos was a very significant amount of money. And the breakdown of Pintor's demands is incredibly specific, arrogant, and highly coercive.
What did he want?
Well, he wants 5,000 pesos cash handed directly to him, allegedly just to persuade his own client to drop the case. He demands a formal public apology from Laconico to be delivered in front of the entire student body of Don Bosco Technical High School. And he wants 1,000 pesos given as a donation to the Don Bosco Faculty Club.
It's designed to be maximally humiliating and financially draining.
It gets worse. He even demands that Laconico transfer his own son to another school or section entirely. Plus, he requires a signed agreement not to divulge the terms of this shady settlement to the mass media and tax on another 2,000 pesos for his own attorney's fees.
Wow. It is a comprehensive list of demands intended to completely subjugate Laconico.
So Laconico realizes he is being actively extorted by a fellow officer of the court. He is terrified but wants to handle it smartly. He calls up his trusted lawyer friend, Edgardo Ganon, and asks him to come to his office to advise him.
Smart move.
Yeah. When the extortionist, Pintor, calls back to finalize the ransom demands, Laconico motions to his friend Ganon to secretly pick up the extension telephone sitting right there on the desk so Ganon can listen in and hear the criminal demands with his own ears.
This is a very common office setup, especially in the 70s and 80s. One main phone line and an extension unit on the same desk, or perhaps in the secretary's room next door.
Right. So Galenon carefully picks up the receiver. He breathes quietly. He listens in on the extension and hears the entire extortion plot unfold directly from Pintor's mouth. Armed with this confirmed intelligence, Laconico contacts the Philippine constabulary.
Now for the sting.
Exactly. They set up a classic sting operation at a local spot called the Igloo Restaurant. Pintor shows up, receives the marked extortion money, and the authorities immediately swoop in and arrest him.
A textbook successful sting operation, entirely built on the intelligence gathered from that monitored phone call.
But here is the unbelievable, almost comedic turn of events. Pintor, the arrested extortionist who was caught red-handed with the cash, turns around and files criminal charges against Ganon and Laconico.
Audacity, I know.
He accuses them of violating the Anti-Wiretapping Act. He claims they secretly overheard his private communication without his unanimous consent. And the wildest part, initially, the lower courts agreed with the extortionist. They found Ganon and Laconico guilty and sentenced them to 1 year in prison.
The lower courts were applying the exact same logic we just saw in the Ramirez case. They looked at the situation and saw an unconsented interception of a private conversation and assumed it fell under the blanket prohibition of RA 4200.
But the Supreme Court stepped in and overturned it. Ganon was ultimately acquitted, completely cleared of all charges. Why? How on earth does listening in on an extension phone not violate a law that explicitly prohibits secretly overhearing a private communication?
This is where we dive into the fascinating mechanics of statutory construction. The Supreme Court had to ask a very precise, technical question. Is an ordinary, everyday extension telephone legally covered by the phrase, any other device or arrangement found in Section 1 of the Anti-Wiretapping Law?
Because, as we noted earlier, the law lists very specific James Bond-style things. Dictaphone, dictograph, detectaphone, walkie-talkie, tape recorder. The words extension telephone do not appear anywhere in that text.
Precisely. And in the realm of legal interpretation, there's a fundamental principle used when reading lists. It's a Latin term, ejusdem generis.
Okay, let's break that down for the listener. What does ejusdem generis actually mean in practice?
Let's say I write a rule for a public park. The sign says, no cars, trucks, motorcycles, or other vehicles allowed on the grass.
Okay. Makes sense.
Now, a kid rides a skateboard onto the grass. Is a skateboard a vehicle? Technically, yes, it transports you. But under the rule of ejusdem generis, when a general phrase like other vehicles follows a specific list, like cars, trucks, motorcycles, the general phrase should be understood to include only things of the same specific kind or class as those listed.
Ah, I see.
Cars, trucks, and motorcycles are all motorized, heavy, street-legal machines. A skateboard is not in that same class. Therefore, the skateboard is not prohibited by that specific rule.
Okay, so the Supreme Court applied this to the wiretapping law. They looked at dictaphones, detectaphones, and tape recorders and asked, is an extension phone in the same family as these things?
Exactly. And the court reasoned that an extension telephone is fundamentally not in the same category. Why? Because an extension telephone is not an instrument whose precise, intended, manufactured purpose is to tap a line or secretly record. It is a common, everyday device used for ordinary, open communication.
Makes sense.
The prohibited devices listed in the law, like a dictograph or a wiretap clip, are inherently designed for surveillance, covert interception, or permanent recording. A standard extension phone just happens to share a copper line for convenience.
But wait, the result is the same, isn't it? Gaydon still heard a private conversation he wasn't invited to.
True, but the court emphasized a foundational, non-negotiable rule of criminal law. Penal statutes must be construed strictly in favor of the accused. When the state is trying to take away your liberty and put you in a cage, the rules must be crystal clear.
No ambiguity allowed.
Right. If there is legitimate linguistic doubt about whether a common extension phone qualifies as a prohibited device under this specific statute, that doubt must be resolved by excluding it. You cannot send a man to prison based on a vague or overly broad interpretation of a word.
That makes perfect logical sense. You shouldn't go to prison because a judge decides to stretch the definition of a 1960s gadget. But the Supreme Court didn't just stop at grammar and Latin phrases. They actually dug into the historical archives.
They did.
They looked at the 1964 Senate deliberations, the literal transcripts of the lawmakers debating the bill before it became law.
This is where we uncover the true legislative intent, the why behind the text. The court records quote the exchanges between Senator Tañada and Senator Diono, the architects of the law. And this historical record reveals a crucial fact. The lawmakers originally considered including telephone party lines and extension phones in the prohibition, but they intentionally debated it and deleted it from the final draft of the bill.
Wait, really? Why would they intentionally delete it if they were so obsessed with privacy?
Because their primary paranoia was not about mere eavesdropping. They were significantly more concerned with penalizing the act of recording. Senator Tañada explicitly stated on the Senate floor that the bill intended to prohibit the use of tape recorders and electronic devices to intercept conversations that would later be used as physical evidence in court.
Oh, wow.
They feared recordings because a physical tape is a dangerous permanent weapon. It can be spliced, it can be altered, it can be played out of context to fabricate testimony or used to facilitate blackmail.
So if I just listen on an extension cord and I go to the police, it is still just my human word against your human word. My memory is fallible. But if I have a magnetic tape, I have an infallible permanent weapon that can destroy you.
Exactly. Mere human listening, relying on the frailty of human memory, simply didn't pose the same existential systemic threat to society that a permanent, potentially manipulatable physical recording did in the minds of the 1965 Senate.
That is a fascinating psychological distinction. The law fears the permanence of the medium more than the breach of the secret. And this logic of intent versus technology extends to another wildly common scenario the court discussed to prove their point. Accidental eavesdropping.
Ah, yes, the crossed lines phenomenon. This is a perfect illustration of why intent matters.
Right. For anyone who didn't grow up with older analog phone systems, let me explain this. Back in the day, telephone infrastructure was literally millions of physical copper wires. Sometimes you would pick up the phone in your kitchen to dial a friend, and before you even touched a number, you would suddenly hear two complete strangers talking clearly on the line.
It happened all the time.
The physical cable loads were overloaded, and the electrical signals literally bled into each other. The Supreme Court, in the Ganon case, explicitly brought this up as a hypothetical. They said, imagine an unwary, innocent citizen picks up their phone, accidentally gets a crossed line, and happens to overhear two criminals meticulously plotting a bank robbery.
Under a broad, non-literal interpretation of the law, what would happen to that citizen?
If the law just said hearing private things is illegal, that citizen would be terrified to call the police. They would technically be guilty of secretly overhearing a private communication using a device, their own telephone.
And the Supreme Court stated that the law was never, ever intended to produce such mischievous results. A legal system that paralyzes a good Samaritan from reporting a bank robbery because they fear a wiretapping charge is a broken system.
Absolutely.
The court clarified that there must be a deliberate, physical intent to intercept, like physically splicing a wire on a telephone pole or installing a hidden battery-operated bug under a table. Merely picking up a legally installed phone and hearing something by pure structural accident lacks that fundamental criminal intent.
So I want to make sure the listener is completely tracking the bizarre reality of this. Let me map this out with a modern-day office scenario. The law punishes the nature of the device and the physical intent much more than the actual emotional breach of privacy itself. So if I hear your secret on an extension phone, I'm innocent. But if I put a tape recorder next to that same phone, I'm going to jail. Say I am sitting in my cubicle and I pick up the office extension phone and I secretly, deliberately listen to my boss confessing to massive corporate fraud. I'm completely innocent of wiretapping under RA 4200. I can go straight to the police.
Yes, you can.
But if I take my smartphone, open the voice memos app, and place the microphone right next to the earpiece of that exact same extension phone to record that exact same confession, I am suddenly a criminal looking at 6 years in jail.
You have grasped the precise, maddening legal quirk perfectly. That is exactly correct. The act of using an extension phone is not a crime because the device isn't inherently categorized for tapping, and listening doesn't create a permanent record. The act of using a tape recorder or a digital voice memo app is a crime because that is exactly the mechanism the statute prohibits to prevent the creation of permanent, unconsented audio records.
It feels like a massive gaping loophole, but it is a loophole created entirely by strict, unwavering adherence to the exact letter of the law. Okay, so we have established that private citizens face severe, almost contradictory restrictions regarding these analog devices.
They certainly do.
But this leads us to the next massive piece of the puzzle. What happens when it's not Socorro Ramirez or Attorney Gannon listening? What happens when the government needs to listen in? How does the immense power of the state navigate RA 4200?
This brings us to Section 3 of the Anti-Wiretapping Act, which deals with authorized wiretapping. It's important to note that the state does have the power to listen. They are not completely blind and deaf, but it is not a blank check. It is a highly restricted, heavily burdened, heavily monitored process specifically designed for peace officers.
They can't just walk into a telephone exchange building with a pair of alligator clips whenever they get a gut feeling about someone.
Absolutely not. They need a written court order from a court of first instance, and obtaining that order from a judge is an incredibly steep uphill battle.
The legal sources outline the criteria, and it is a very specific and frankly very intense list of eligible crimes. A judge will not grant a police officer a wiretap for a petty theft, a local burglary, or even a standard drug bust. The law strictly limits authorized state wiretapping to cases involving treason, espionage, provoking war, piracy, mutiny on the high seas, rebellion, sedition, and kidnapping.
Let's look at that list for a moment. Treason, espionage, provoking war, mutiny, rebellion. That specific catalog of offenses tells you everything you need to know about the psychological mindset of the era when this law was drafted.
It's a list of apocalyptic state emergencies. But even if the crime is on that list, let's say the police suspect a rebellion is being planned, the peace officers still have a massive burden of proof before a judge will hand over that warrant. They have to demonstrate 3 incredibly strict conditions. First, they must show reasonable grounds that the crime is actively happening or about to happen. Second, they must prove that essential evidence will definitively be obtained by tapping the phone. And third, and this is the one that seems like a massive operational hurdle, they must prove that no other means are readily available for obtaining this evidence.
Let's spend some real time on that no other means clause because it is the linchpin of the restriction. How does a police officer prove a negative to a judge? They have to convince the court that traditional police work has completely failed or is physically impossible.
That sounds tough.
It is. If the police can get the evidence by flipping a low-level informant, the judge must deny the wiretap. If they can get the evidence through physical surveillance, tailing the suspect, or executing a standard search warrant on a property, the judge must deny the wiretap.
So the police practically have to go to the judge and say, Your Honor, we have tried undercover agents, we've tried informants, we've looked in their trash, and we have absolutely nothing. The only way to stop this rebellion is to listen to this specific phone line.
Exactly. It positions wiretapping not as an investigative tool, but as the absolute desperate last resort. It highlights just how profoundly invasive the 1965 lawmakers considered wiretapping to be. They viewed it as a necessary evil, only to be deployed when the survival of the state was literally on the line.
And even if the police managed to jump through all those hoops and get the order, there is a ticking clock. It's not a lifetime subscription to someone's phone line.
It is a very strict timeline. The authorization only lasts for a maximum of 60 days. If they haven't found the evidence in 2 months, they have to stop. And arguably, the post-wiretapping protocol, what happens after they hit stop, is even stricter than the application process.
Oh yeah, the handling of the physical tapes. The sources are incredibly pedantic about this. Within 48 hours after that 60-day authorization period expires, the police officers must take all the physical recordings, put them in a sealed envelope or a secure package, and deposit them physically with the court.
Hand them right over to the judge.
Yeah, they can't keep a copy in the precinct. They have to swear a legally binding affidavit detailing exactly how many tapes there are, the dates they were recorded, the times, and certify under penalty of perjury that absolutely no duplicates exist anywhere else in the world.
It is an extreme chain of custody mandate. And think about why it's so strict. It is designed to completely prevent the police from leaking the tapes to the press, using them for political leverage or blackmail against opposition leaders, or taking them into a back room and splicing them to alter the context.
Makes sense.
And the most vital protective part of this protocol is that once that sealed package is deposited with the judge, the police cannot open it, they cannot replay it, and they certainly cannot use it as evidence in a trial without going back and getting a separate subsequent court order just to open the envelope.
Wow.
And crucially, the person who is recorded must be legally notified and given a chance to appear in court and argue against the tapes being opened.
It is layers upon layers of judicial oversight, wrapping the process in red tape to protect the citizen. But I have to push back on something here and indulge in a bit of modern speculation. I'm looking at that list of eligible crimes again. Treason, piracy, rebellion, kidnapping. I notice kidnapping is on there, which is a terrible violent crime against an individual. But what about murder? What about a massive serial killer investigation where the killer is taunting the police over the phone?
It's a valid question.
Or what about massive corporate financial fraud that bankrupts millions of working class people? Why are those excluded while something like mutiny on the high seas gets a wiretap?
If we connect this to the bigger picture, you have to look at the date again, 1965. The law was heavily focused on national security, warfare, and high-level existential threats to the state itself. Treason, espionage, rebellion, these are crimes that threaten to topple the government. Kidnapping is the slight outlier, likely included because organized kidnap for ransom syndicates were a significant destabilizing threat to societal order at that specific time in Philippine history. But the overarching theme is geopolitical anxiety.
So the state didn't care as much about individual murders as they did about a communist takeover.
Essentially, yes. The state was restricting its own surveillance powers, choosing only to unleash them when the state itself was in peril, rather than for ordinary criminal investigations, even severe ones like murder. It reflects a deep post-World War II Cold War societal fear of a totalitarian police state, casually monitoring its citizens' everyday lives. They built a wall so high, the police could only climb it during a war.
It is utterly fascinating how a single piece of legislation is essentially a time capsule. It captures the exact fears, technologies, and paranoias of a nation at the exact moment the ink dried on the paper. So, we have this 1965 law, perfectly tailored for dictaphones, physical copper phone lines, and Cold War treason. But let's transition to the modern era. What happens when the wire disappears entirely?
The big shift.
What happens when human communication moves off the physical copper cables into the air and onto the internet? Let's talk about the digital leap, Skype, cyber sex entrapment, and the audacious not-a-wire defense.
This is where the strict textual interpretation we discussed in the analog era faces its absolute greatest challenge. You have the inflexible language of 1965 meeting the borderless wireless technology of the 2010s.
Let's think forward from 1965 to the years 2013 and 2014. We have the chilling case of People of the Philippines v. Vincent Rodriguez. This is a deeply dark case. Rodriguez was engaged in human trafficking and cybersex operations involving minors. The sources outline a very detailed, multi-agency police operation against him.
It was a sophisticated operation initiated by international intelligence sharing, highlighting how borderless these crimes have become.
Right. The U.S. Immigration and Customs Enforcement, or ICE, flagged this activity and tipped off the Philippine Regional Anti-Human Trafficking Task Force. They warned them about a user operating under the name Elo Rodriguez who was offering horrific services online. The Philippine police assign a cybercrime officer, PO3 Gambi, to investigate. Gambi creates a decoy Facebook account under the fake name Tristan James.
He goes undercover digitally, establishing a persona to infiltrate the network.
He does. He searches for Rodriguez on Facebook, sends a friend request, and eventually Rodriguez accepts. They start chatting. And Rodriguez, who uses various Skype accounts with names like Sofia.Negra and Cassandra.Labajo, starts aggressively offering nude shows involving young girls. At one point in the chat logs, he demands $50 for a specific show.
And Gambi plays along.
Yeah, Gambi, playing the role of a wealthy businessman based in Guam, coordinates with an agent to actually send the money via Western Union to build the case. But Rodriguez is paranoid. He gets spooked, messaging that the police are very hot on nude shows right now, and he backs out of the online show while sitting at an internet cafe.
The digital trail is strong, but Rodriguez's paranoia makes it difficult to secure the final piece of evidence online. So the police don't give up. They escalate the operation. They move it from the digital realm to the physical realm.
Exactly. Gamby changes tactics. He pivots. He tells Rodriguez that a foreign friend of his, named Kyle Edwards, is currently visiting the Philippines and is staying at the waterfront hotel in Cebu. Rodriguez takes the bait immediately. The prospect of in-person cash is too tempting. He offers to bring a 14-year-old minor, referred to as AAA in the sanitized court documents to protect her identity, directly to the hotel room to perform a nude show in person. He even proposes that the foreigner could have sex with them. Rodriguez demands $75 up front just for the taxi fare to get to the hotel. Gamby wires the money and Rodriguez confirms receipt.
This sets the stage for a highly controlled, classic physical entrapment operation. The digital undercover work has successfully lured the target into a physical space where they can be apprehended.
Yes, it's the Valentine's Day sting at the waterfront hotel. The police brief their tactical team. They prepare the crucial piece of evidence, marked money. They take 10 1,000 peso bills and dust them heavily with a specific fluorescent ultraviolet powder that is invisible to the naked eye. An officer, SPO1 Tamagos, acts as the police decoy inside the room. He pretends to be the local driver for a confidential informant who is playing the role of the foreigner, Kyle Edwards.
The precise execution of the sting is critical. One wrong move, and the evidence could be deemed inadmissible.
The tension is high. Rodriguez arrives at the hotel room with the 14-year-old minor. The informant opens the door, introduces Tamagos as his driver, and tells Tamagos to hand over the cash. But Rodriguez is cautious. He's a veteran of this illicit trade. He refuses to take the money directly from the driver's hand. He tells Tamagos to just leave the money on the table.
Trying to avoid direct contact.
Right. Tamagos puts it down and leaves the room to signal the tactical raid team waiting in the hallway. As he is leaving, the informant picks up the money from the table and hands it directly to Rodriguez. Rodriguez, perhaps feeling the deal is done, finally accepts it and holds the cash. At that exact moment, the police raid the room, arrest Rodriguez, and secure the safety of the minor.
And the physical evidence they gather in that moment is completely undeniable.
Right. They immediately swab and test Rodriguez's hands under a UV light. Both the dorsal and palmar aspects, the back of his hands and his palms test, glaringly positive for the bright orange fluorescent powder from the marked money. He was caught red-handed. Literally, his hands were glowing.
The prosecution has a seemingly bulletproof case based on the physical entrapment and the marked money. But in court, the battle shifts back to the digital surveillance that led up to the hotel sting.
This is where Rodriguez attempts a desperate and frankly audacious legal defense. During the trial, the prosecution naturally introduces the chat logs from Facebook and the video recordings of the Skype calls that PO3 Gamby made during the months of undercover phase. Rodriguez's defense team stands up and objects. They try to use RA 4200, the Anti-Wiretapping Act from 1965, to escape justice for human trafficking.
That's unbelievable.
They argue that PO3 Gamby secretly recording their Skype video calls and saving the Facebook chat logs was illegal wiretapping, because Rodriguez never consented to being recorded. Therefore, under the law, all that digital evidence should be thrown out as fruit of the poisonous tree.
It is a stunningly bold move. He is attempting to take the legal shield, specifically designed to protect citizens from 1965 analog phone taps, and use it to protect his 2014 cybersex operation. It forces the Supreme Court into a corner. They have to confront the absolute limits of the statute's language.
How did the Supreme Court respond to this? Did they let a human trafficker walk free on a technicality because of a law written before the internet was invented?
No, they did not let him walk. And the way they defeated his argument is fascinating because they employed the exact same literal textualist approach we saw in the GoNAN extension phone case. The court refused to update the law. Instead, they looked back at the precise, rigid text of 1965.
What did the text say again?
The law explicitly prohibits tapping any wire or cable or using a device to intercept communication, commonly known as a dictaphone or dictograph or tape recorder. The Supreme Court ruled that Skype, which utilizes Voice over Internet Protocol, or VoIP, is fundamentally technologically not the same as tapping the main line of a telephone.
Because there is no physical wire being tapped in the traditional sense. It's not an electrical signal moving down a dedicated copper line between two houses. It is digital data packets being broken down, sent into the ether of the internet, bouncing off servers globally, and reassembling on the other side.
Exactly. The court stated in their ruling, "By no stretch of the imagination can the recording of Skype conversations and pictures be of the same nature as tapping the main line of a telephone. Therefore, because the digital technology of VoIP simply didn't fit the literal analog definitions written in 1965, recording a Skype call does not violate the Anti-Wiretapping Act." The digital evidence was deemed fully admissible, and Rodriguez was convicted.
It is the ultimate legal irony. Think about this. The strict literalism that made recording your own abuser a crime in the Ramirez case because she used a tape recorder is the exact same strict literalism that allowed the police to record a human trafficker because they used Skype.
It's a double-edged sword.
I have an analogy for this. It is like trying to enforce 19th century horse and buggy speed limits on a modern hovercraft. The Old Town Law says, "No horse shall gallop faster than 10 miles per hour through the town square." The hovercraft comes speeding through at 60 miles an hour. The sheriff tries to write a ticket, but the judge says, the hovercraft doesn't have a horse, so the law simply doesn't apply. The law was so obsessively, restrictively specific to the physical technology of its time that modern digital communication simply flies right over it.
That is an incredibly apt analogy. The technological leap forward simply rendered the specific prohibitions of the statute obsolete in that particular digital context. The Anti-Wiretapping Act is effectively and permanently tethered to analog technology.
Which brings us to a massive, slightly terrifying realization. If the Anti-Wiretapping Act, this incredibly strict law that sends people to jail for 6 years for using a tape deck, doesn't apply to Skype and doesn't protect our digital chats, our Facebook messages, our WhatsApp logs, what does? Is it just the Wild West? Can anyone just hack my phone, read my messages, and use them against me? Does the constitutional right to privacy step in to protect our direct messages? Let's dive into the final, most modern case we have, the Cadazas case and the doctrine of the poisonous tree.
The Cadazas case from 2021 is a landmark Supreme Court decision. It is essential reading for anyone living in the digital age because it directly addresses the boundaries of privacy, consent, and constitutional rights in a social media-dominated world.
Let's lay out the narrative carefully. The case involves Christian Cadazas, who was a 24-year-old adult man, and a minor, AAA, who was only 14 years old. They met, they communicated heavily over Facebook Messenger, and eventually they entered into what Cadazas claimed was a romantic relationship.
A critical non-negotiable detail here is the severe age disparity. You have a 10-year difference crossing the legal threshold of adulthood, with one party being a young minor.
Right. Now, AAA's mother, referred to as BBB in the court records to protect the family's identity, discovers that this relationship is happening, and she is understandably furious, deeply upset, and extremely disapproving because her daughter is a child.
And the mother does not just sit back, she takes decisive investigative action.
She does. AAA had left her Facebook account logged in on her mother's mobile phone, or perhaps was using it in front of her. The mother confronts AAA and forces her to open Cadazas' Facebook Messenger account. AAA was able to do this, and this is the crux of the whole legal battle, because Cadazas had voluntarily given AAA his personal password.
A huge mistake on his part.
So, the mother makes the daughter log in, and when the mother starts scrolling through the private chat logs between the 24-year-old man and her 14-year-old daughter, she discovers something horrifying. The chat logs provide written proof that Cadazas was actively coaxing, manipulating, and inducing AAA to send nude photos of herself. He was repeatedly sending explicit messages like, "Siege Hubad," which translates to, "Go ahead, undress."
The mother immediately secures these chat logs. She doesn't need a wiretap. She has the digital text. And this evidence becomes the absolute foundation for severe criminal charges against Cadazas for child pornography under the Cybercrime Prevention Act and the Anti-Child Pornography Act.
During the trial, facing serious prison time, Cadazas tries two major legal defenses. The first is what the courts often refer to as the sweetheart defense. He basically stands up and argues, look at the context. We were in a romantic relationship. She consented to this. We loved each other. This was just intimate, consensual banter between a couple.
And this defense forces the court to rigorously address the psychological and legal concept of consent, specifically regarding minors in the digital age.
The Supreme Court completely and utterly dismantled the sweetheart defense in this context. They ruled that while a sweetheart defense might sometimes mitigate circumstances between two consenting adults, it is absolutely categorically inapplicable here. The court emphasized that minors, especially young teenagers going through puberty, are in a stage of intense hormonal change, emotional vulnerability, and physical curiosity. But experiencing those changes does not mean they possess the psychological maturity or the legal capacity to give rational, informed consent to explicit sexual activity or the production of pornography.
The court focused heavily on the inherent, inescapable power imbalance. A 24-year-old adult man wielding emotional influence over his 14-year-old child creates a dynamic where true, uncoerced consent is fundamentally impossible. The child is uniquely vulnerable to cajolery, manipulation, and deception. The court stated that under the doctrine of parens patria, which means the state acting as the ultimate protective guardian of those who cannot protect themselves, the government has a supreme obligation to intervene and protect minors from sexual predators, regardless of whether the minor mistakenly thought they were consenting in the context of a so-called relationship.
And this ties into a really interesting, deep legal distinction that the sources bring up. The difference between malum in se and malum prohibitum. I know we touched on Latin earlier, but let's strip away the Latin here. Explain why this distinction destroys his defense.
Certainly. These are two of the most foundational concepts in all of criminal law. Malum prohibitum refers to an act that is wrong merely because a human-made statute arbitrarily prohibits it. Think of a parking violation or driving with a registration sticker that expired yesterday.
Sure.
Parking in a loading zone is not inherently evil. It doesn't harm the fabric of society. It is just against the rules to keep traffic flowing. In malum prohibitum crimes, your intent usually doesn't matter. If you park there, even by accident, you're guilty.
Okay, so that's a rule violation? What is malum in se?
Malum in se translates roughly to wrong in itself. It refers to an act that is inherently wrong, evil, depraved, or deeply immoral in its very nature, regardless of whether a politician ever bothered to write a law down to prohibit it. Murder is malum in se. Theft is malum in se. And in this case, the Supreme Court unequivocally ruled that child pornography is malum in se.
It's just inherently wrong.
Yes. Grooming and inducing minors to produce explicit images is inherently universally depraved. Because it is malum in se, the law requires the prosecution to prove criminal intent. You can't accidentally commit an inherently evil act. But the court found that Kadajis's explicit demanding messages in the chat logs, telling her to undress clearly, undeniably proved his criminal intent to induce the minor.
Okay, so the sweetheart defense completely fails. The act is inherently evil, and the chat logs prove he intended to do it. Seeing that his first defense is crumbling, Cadelas pivots to a second and perhaps most legally fascinating defense for our modern lives, the privacy defense, the constitutional right to privacy, invoking the fruit of the poisonous tree.
This is where heavy constitutional law collides violently with everyday digital data.
Cadejas argues to the judge that the mother, BBB, obtained those highly incriminating Facebook chats by illegal snooping. He claims that by forcing her daughter to open his account, the mother flagrantly violated his constitutional right to privacy. Therefore, under the fruit of the poisonous tree doctrine, which says that if the source of the evidence is tainted, the evidence itself cannot be used. The chat logs must be thrown out of court. And if the chat logs are thrown out, the prosecution has no case, and he walks free.
It is a defense that swings for the fences. It relies on invoking the absolute highest law of the land, the Constitution. But the Supreme Court's response to this is a masterstroke of modern jurisprudence. They provide three monumental insights into how privacy actually works today.
Let's break down those 3 points, because this is the big aha moment for anyone who uses a smartphone. What was the court's first major point?
The first point is a lesson in fundamental constitutional law that most people misunderstand. The Bill of Rights, which enshrines the right to privacy, is structurally designed to protect private citizens against the overwhelming power and overreach of the state, meaning the police, the military, the government agencies. It is a shield against state tyranny. It is generally not applicable against actions taken by ordinary private individuals.
Wait, so if a police officer hacks into his Facebook account without a warrant, that is a massive constitutional violation, and the evidence is thrown out. But if a furious mother grabs an iPad off the kitchen counter and reads the messages, it is not a constitutional issue at all.
Exactly. The exclusionary rule, the rule that throws out poisonous evidence, is meant to punish and deter police misconduct. It doesn't apply to the actions of a private citizen acting on their own initiative. The mother, BBB, is a private individual. She is not an agent of the state. Therefore, Kadajis simply cannot invoke his constitutional right to privacy against her personal actions to suppress the evidence in a criminal trial.
That is a massive distinction. The Constitution protects you from the government, not from your family. But still, what about the fact that it was his personal Facebook account, heavily password protected? Doesn't he have a basic human expectation of privacy there? That leads to the court's second point, which I think is going to shock a lot of listeners.
This is perhaps the most significant practical point for our everyday digital lives. The court ruled that by voluntarily choosing to give his Facebook password to AAA, Kadages effectively waived his reasonable expectation of privacy, at least concerning her and anyone she might allow or be forced to see it.
Okay, here is where it gets really interesting, and I have to push back on this hard because the implications are terrifyingly huge. Are you telling me that the court is essentially saying that the moment you hand over your digital keys, you lose your privacy shield entirely? Let's apply this to real life. If I share my Netflix streaming password with my girlfriend so we don't have to pay for 2 accounts, or if I give my partner the passcode to unlock my iPhone just so they can change the music while I'm driving on the highway, am I legally leaving the front door of my constitutional privacy wide open? Does giving out a password mean I legally consent to being surveilled?
This raises a profoundly important question, and it's one legal scholars are actively debating. The court's ruling strongly suggests that, yes, you are significantly diminishing, if not entirely obliterating, your legal expectation of privacy. When Kadages gave his password to AAA, he formally authorized her access. He voluntarily surrendered his exclusive control over that digital vault.
Man, that's heavy.
The court reasoned that you cannot stand before a judge and claim a strict, ironclad expectation of privacy when you yourself have voluntarily handed the master keys to someone else. The fact that the mother forced AAA to use those keys later doesn't change the foundational fact that Kadages voluntarily gave up his absolute right to exclusivity the moment he shared the password.
It is a brutal, harsh lesson in digital hygiene. The legal takeaway is, never, ever share your password with anyone if you want to maintain an absolute legal claim to privacy in a court of law. Once the key is copied, the vault is legally compromised. But the defense team had one more angle. They argued, okay, maybe the Constitution doesn't apply to a private citizen, but what about the Data Privacy Act? Republic Act 1173, doesn't that modern law specifically protect his sensitive personal information from being processed or shared without his consent?
It does offer protection, yes. But the Data Privacy Act is not an absolute impenetrable shield either. And this is the court's third and final point that sealed his fate. The DPA contains specific, explicit, written exceptions. The law legally allows for the processing and sharing of sensitive personal information when it is strictly necessary for the protection of lawful rights, to establish legal claims, or to determine criminal liability.
So let me connect the dots. Because the mother wasn't just being a nosy gossip because she was actively gathering evidence of a severe crime, child pornography, and was preparing to file formal legal charges to protect her daughter's lawful rights, the Data Privacy Act essentially stepped aside and allowed the use of those messages.
Exactly. The Data Privacy Act is designed to protect your data from corporate misuse, telemarketers, or unwarranted public exposure on the internet. But it is fundamentally not designed to be a safe haven or a hiding spot for criminal evidence when a victim or a victim's guardian is seeking justice in a court of law.
Wow. So combining those 3 massive legal points. First, the Constitution only protects you against the government, not an angry mom. Second, sharing your password voluntarily waives your expectation of privacy. And third, the Data Privacy Act allows evidence gathering for crimes. Kadages' digital vault wasn't just cracked, it was blown wide open, legally and completely.
The Supreme Court systematically, point by point, dismantled every modern privacy defense Kadages raised. They masterfully adapted traditional legal concepts like the limits of the Bill of Rights to the messy realities of a password-shared Facebook Messenger world.
Which brings us to the end of this incredibly dense journey. Let's summarize what we've unpacked today because it connects directly back to you, the listener, and that smartphone you pictured at the beginning. We have seen that the laws governing our most private, intimate moments are not a single, cohesive, logical shield. They are a deeply fragmented patchwork.
It is a patchwork built from incredibly strict, literal rules designed for the 1960s analog era, violently colliding with rapidly evolving, sometimes contradictory interpretations of modern digital data acts. It requires constant legal navigation.
It is a landscape of bizarre, almost comical contradictions. Think about what we learned. If you accidentally pick up an extension cord and hear a bank robbery being plotted on a crossed telephone wire, you are an innocent citizen acting within the law. But if you hit record on a tape deck to document your boss screaming abuse in your face, you could be branded a criminal facing 6 years in jail. Yet, if the police record a cybersex trafficker over Skype, that is perfectly fair game because a judge decided the internet is not a literal wire.
And perhaps most importantly for everyday life, if you share your password with your partner for convenience, you might just be waiving your legal expectation of privacy entirely. Deep knowledge of these specific nuances is absolutely crucial in the digital age. Ignorance of the mechanism can cost you your freedom.
It really is. And I want to leave you with a final provocative thought to ponder as you go about your day. We spent a long time talking about dictaphones, extension cords, Skype calls, and Facebook passwords. But technology is not stopping to wait for the law to catch up. It is accelerating. It is actively moving away from screens and keyboards. We are moving rapidly toward ambient computing smart home assistants that are always sitting on your kitchen counter, always listening in the background of your living room. We are moving toward a neural link brain-to-text communication where you don't even type. You just think a message and it sends.
The frontier of privacy is shifting dramatically. It's moving from the physical devices we hold in our hands to the invisible environment we inhabit and eventually to the biological, neurological signals we produce.
Exactly. So here's the question you need to ask yourself. As we enter that era, how will the courts define a private communication? If a law from 1965 is struggling mightily to comprehend a Facebook message today, what happens when the wire being tapped isn't a phone line and isn't an internet cable, but the neurological signals inside our own minds? When the vault isn't sitting in your hand, but is literally inside your head?
It is a profound legal and ethical challenge. It is a puzzle that the next generation of lawmakers and jurisprudence will inevitably have to face, and the stakes will be higher than ever.
And it is something for all of us to think deeply about the next time we casually click agree to a massive terms of service update without reading it. Thank you for joining us on this deep dive into the source material. Stay curious, fiercely protect your passwords, and always read the fine print. Think back to that digital vault in your hand. The padlock securing it might be much, much older than you think. Until next time.
Welcome to the debate. So, I want you to imagine a massive stone fortress.
Okay, I'm picturing it.
It has these towering, impenetrable walls, a deep moat, heavy iron gates, and it was designed perfectly to do one very specific job.
Which is?
Keeping out an invading army charging in on horseback.
Right, a classic medieval defense.
Exactly. But what happens when the next wave of invaders arrives not on horses, but in airplanes? I mean, they just fly right over the walls. The fortress itself hasn't changed a single stone, but the nature of the threat has evolved entirely.
Yeah, rendering the architecture completely obsolete. The defenders are just left standing on the ramparts, holding their shields, bracing the gates, while the real intrusion is happening silently right above their heads.
And that image perfectly captures what we are looking at today. We are examining the intersection of the Philippines Anti-Wiretapping Act, Republic Act number 4200, which was enacted way back in 1965, and, well, its application across our rapidly evolving communication technologies.
Right, we're dealing with a legal fortress built for copper wires and physical switchboards, but it's now facing the invisible, wireless reality of the digital age.
Precisely.
And the central question we have to grapple with in this discussion is this. Does a strict, literal interpretation of that Anti-Wiretapping Act, one that focuses precisely on the physical mechanism of interception, safeguard the justice system from punishing innocent citizens? Or, on the flip side, does that rigid reading create dangerous loopholes that violate the very spirit of privacy the law was originally designed to protect?
And I represent the perspective that a strict textualist interpretation of the law is not just legally sound, but entirely necessary. By restricting the law's application to specific physical interventions, like literally tapping a main telephone line, the courts rightfully avoid criminalizing everyday technology use. More importantly, as we'll see, this strict reading prevents the accidental exclusion of vital digital evidence in the prosecution of severe crimes.
And I take the opposing view here. I argue that rigid technological liberalism completely undermines the law's core intent. I mean, if we focus entirely on the physical wires, we create an inconsistent, almost absurd legal framework.
Absurd how?
Well, we end up in a situation where a citizen's fundamental right to privacy depends entirely on the specific gadget being used to spy on them, rather than their actual reasonable expectation of privacy.
Okay, let's lay out the foundation of the textualist position first, because I want to be clear on why the text matters so much. RA 4200 was explicitly written in a very specific era to prevent a specific physical act.
Right, physical tapping.
Yes, the physical tapping of wires and the deliberate installation of espionage devices. The text specifically lists devices commonly known as a dictaphone, a dictograph, a dictaphone, or a walkie-talkie.
Very 1960s tech.
Exactly. And it is a fundamental principle of our legal system that penal statutes, laws that can literally send a citizen to prison for years, must be construed strictly in favor of the accused.
Sure, but
If we casually expand this law beyond its exact text to include everyday modern items like a shared office phone or an internet app, we invite disastrous results. We risk punishing an unwary citizen who accidentally overhears the details of a crime on a cross telephone line, paralyzing people from reporting what they hear to the police out of fear of being imprisoned themselves.
I understand the instinct to cling to the text when prison time is on the line. I really do. But we cannot ignore the animating spirit of the legislation. The undeniable spirit of RA 4200 is to protect the sanctity of private communication and the spoken word from unauthorized secret interception.
Right, but
It is meant to protect people from being recorded without the consent of all parties involved. Look at the jurisprudence. In the case of Ramirez versus Court of Appeals, a private citizen secretly recorded a highly volatile confrontation with her boss using a tape recorder.
yes, the tape recorder case.
Even though she was a participant in the conversation, the court deemed that recording illegal because she did not have her boss's consent. The harm the law is targeting is the secret capture of a private moment. Concluding that someone using an alternative device is suddenly exempt simply because they didn't physically splice a copper wire completely strips citizens of meaningful privacy protections.
I hear that. But to understand why the physical mechanism actually matters legally, we have to look at the anatomy of a tap. How did a 1965 wiretap actually work?
Well, he had physical circuit-switched copper wires.
Right. A connection required a dedicated, unbroken electrical path from caller to receiver. To intercept it, an operative literally had to find that wire, strip the insulation, and attach alligator clips to siphon off the electrical signal. It was a deliberate, physical intrusion.
Okay.
And that brings us to the first major technological test of this law, which is the extension telephone. This was explored deeply in the case of Galón versus Intermediate Appellate Court.
Ah, yes. The classic debate over what constitutes a device or arrangement under the statute.
Exactly. So in Galón, you had a complainant who was demanding an 8,000 peso extortion settlement over the phone to withdraw a direct assault charge. The person receiving the call asked his lawyer to listen in secretly on an ordinary office extension phone.
Without the caller knowing.
Correct. But the court ruled that an extension phone is not a dictograph or a dictaphone. Its primary manufactured purpose is ordinary office communication, not clandestine interception. The court relied on the reality of common experience. When you call a number in an office building, it might ring on multiple instruments. The caller inherently assumes the risk of a party line.
I have to push back on that, though, because the logic in the Ganian ruling creates a functional absurdity. Let's really look at the mechanics of what happened. A lawyer secretly listens to an extortion negotiation on an extension phone without the caller's knowledge or consent.
Right.
He then uses what he heard to file robbery and extortion charges. Functionally, the violation of privacy is identical to using a wiretap. The caller genuinely believed they were having a private one-on-one conversation.
But they weren't on a secure line.
The fact that the interloper was using a secondary handset instead of a spy-grade detectaphone shouldn't magically erase the privacy violation. The clandestine act of listening in, the betrayal of confidence, is exactly the same.
I see why the outcome feels like a loophole. I really do. But let me explain why the court has to rule that way using a critical rule of statutory construction. In law, there's a principle which dictates that particularization followed by a general expression is restricted to the former.
Meaning?
Think of it this way. If a public park posts a rule banning bicycles, skateboards, and any other vehicle, it is clearly prohibiting modes of human transport, right?
Right.
It is not banning a child's remote-controlled toy car, even though a toy car is technically a vehicle. By listing specific purpose-built espionage tools, dictaphones, dictographs, the law is targeting deliberate surveillance equipment. A standard office telephone extension simply isn't one. The law requires a deliberate installation of a device specifically for interception.
Okay, but if we follow that hyper-literalist logic, we hit a massive wall the moment we transition from analog extension phones to the modern digital era.
How so?
If an extension phone is a crack in the fortress wall, the internet is a gaping chasm. How does a law written for copper wires apply to internet data packets?
Well, it's...
Let's break down the mechanism. With a 1965 landline, there is a dedicated physical copper path between you and me. You can put a clip on it. But if we are talking over Skype or WhatsApp, the software breaks our voices down into thousands of tiny digital packets, fires them into the internet through countless random routers, and reassembles them on the other side.
Right, there's no single wire.
Exactly. There is no continuous line to tap. And because of that, recording a Skype video call or capturing private chat logs is routinely deemed not to be a violation of RA 4200. The court looks at it and says, no physical line, no crime. The medium has changed from copper wires to Wi-Fi, but the Clandestine Act remains exactly what the lawmakers were trying to prevent. It makes the law toothless.
Okay, wait, let me pause you right there. I have to admit, when you look at it purely from the perspective of how the technology functions, it sounds like a massive oversight.
It is. But we have to dig into the legal and societal consequences of what you're suggesting. You are entirely discounting what happens to the justice system if we broadly apply RA 4200 to all digital communications. Let's look at the Rodriguez and Cadajas cases. We aren't talking about minor civil disputes or office politics here. These cases involve child trafficking and child pornography.
Of course. And no one is arguing that we shouldn't prosecute traffickers to the fullest extent of the law.
But the legal mechanics are exactly what dictate how we prosecute them. In Rodriguez, the accused was offering nude shows of minors to foreigners via Skype. Because Skype and Facebook Messenger do not involve tapping a physical wire, the courts ruled that RA 4200 doesn't apply.
Yes, that means the crucial evidence, the chat logs, setting up the transactions, the recorded video calls showing the explicit exploitation, remains admissible in court. If your broad interpretation of the Anti-Wiretapping Act were applied, this vital evidence of Mala and C crimes would be excluded as illegally obtained.
Okay, let's clarify Mala and C for a moment, just so we are on the same page.
Right. Mala and C refers to acts that are inherently immoral and universally recognized as evil, like murder, or in this case, human trafficking. This is in contrast to Mala prohibida, which are acts that are only wrong because a specific statute forbids them, like jaywalking or driving without a license.
Got it.
My point is, if we treat digital chat logs as protected by the 1965 wiretapping law, we shield perpetrators of horrific Mala and Se crimes. Consider the strict conditions peace officers face to get a legal wiretap order. They can only get one for highly specific, severe crimes like treason, rebellion, or kidnapping.
Right, it's a very high bar.
Exactly. If we broadly apply RA 4200 to all digital chats, we completely cripple the prosecution of modern cybercrimes. The law was built to constrain the state from tapping private phones for political leverage. It was not built to shield sexual predators from having their own digital footprints used against them in a court of law.
That is a very powerful argument regarding the utility of the evidence. I concede that. But I want you to really consider the disjointed, contradictory standard this creates regarding who is actually violating privacy.
Contradictory how?
Well, if you're listening to this on a smartphone right now, using Wi-Fi, under this strict interpretation, your baseline privacy protections against another private citizen recording you are incredibly fragile. Let's trace the boundary between state overreach and private disputes, and look at the glaring double standard. Let's return to the Ramirez case for a moment.
The tape recorder again.
Yes, a private citizen records her boss, secretly using a tape recorder, and it is ruled illegal under RA 4200. The tape cannot be used. Now contrast that with the Cadajas case. In Cadajas, a mother discovers her 14-year-old daughter is being lured by a 24-year-old man. The mother physically forces her minor daughter to open her password-protected Facebook account, so the mother can extract the explicit messages to use as evidence.
Which resulted in a righteous conviction because she secured the evidence of the exploitation.
Yes, but look at the privacy framework. Why is the mother's forced extraction of password-protected data admissible? The courts rationalize this by saying the Bill of Rights, specifically the right against unreasonable searches and seizures, protects citizens against the state, not against private individuals.
Right.
But from a purely privacy-focused perspective, this creates a bizarre double standard. If I record my boss on a physical tape recorder, I'm a criminal under RA 4200. If I force someone to open their digital vault and I extract their private digital data, the evidence is pristine simply because the Bill of Rights doesn't apply to me as a private citizen. The law is failing to provide a coherent standard for what constitutes a protected private sphere. It shouldn't matter if the person invading your privacy is wearing a police badge or is just your neighbor.
Hold on. It feels contradictory until you look at who the law is restraining and why. It's not a disjointed standard, it is a precise delineation of legal jurisdictions.
How so?
You brought up the Bill of Rights, the exclusionary rule under the Constitution, the doctrine that makes illegally obtained evidence inadmissible in courts, applies strictly to state actors. That is a feature of our democracy, not a bug.
Well, obviously.
The exclusionary rule isn't there to reward criminals. It exists because the only way to punish a corrupt government or police force for breaking the rules is to throw out their prize, the evidence. We do not apply that same standard to private citizens because private disputes are governed by different tools, namely the Civil Code and the Data Privacy Act.
But the Data Privacy Act is doing the heavy lifting because RA 4200 is fundamentally broken for the digital age.
I rely on those other laws because they are the correct tools for the job. The Data Privacy Act explicitly allows the processing of sensitive personal information when it is necessary for the establishment of legal claims in court proceedings. That is why the mother's evidence in Kadaha's works. RA 4200, on the other hand, is a penal statute. It threatens actual prison time.
Right.
If we stretch a penal statute to cover every new technology, we endanger the public. Let me give you a direct hypothetical based on the text. Because old telephone cables carry heavy loads, cross lines happen.
Sure.
If an unwary citizen picks up their phone and accidentally overhears a murder plot on a cross line, should they hesitate to call the police? Should they fear facing 6 months to 6 years in prison because they used their own telephone and overheard a private communication? No! The law requires deliberate intent and specific espionage devices precisely to prevent such miscarriages of justice.
Okay, your cross-line scenario involves accidental overhearing, and I agree we shouldn't punish accidents. But I am talking about deliberate, intentional, secret recording. Whether that recording happens on a reel-to-reel tape recorder in 1965 or via a screen capture software on a Skype video call today, the malicious intent and the psychological injury to privacy are exactly the same.
But the mechanism...
Think of it like this. If the law is a postal inspector who is only legally allowed to regulate sealed paper envelopes, what happens when society stops sending envelopes and starts communicating by shouting across a crowded digital room? When the courts rule that a Skype recording is admissible simply because it doesn't physically splice a main telephone line, they are abandoning the core philosophy of the law.
I wouldn't say abandoning.
They are. They are essentially saying the right to privacy is entirely dependent on the victim using an antiquated technology. If you use a landline, you're protected by the full weight of a penal statute. If you use voice over IP or a messaging app, you are fair game. That is not justice. That is a technicality overriding a fundamental human right.
But that technicality is exactly what keeps the law objective and measurable. If we allow judges to broadly interpret what constitutes a device or an interception based on the nebulous concept of the spirit of the law, we lose legal certainty. A strict textualist reading of RA 4200 is the only way to maintain a precise definition of forbidden acts.
Even if it's outdated?
Yes, because expanding the law beyond physical tapping risks punishing innocent behavior like an office worker on an extension line or a parent checking a child's device for their own safety. Even more critically, as we saw in the Rodriguez case, it risks discarding essential, irrefutable digital evidence in horrific crimes. The law says what it says. If it needs to cover the architecture of the internet, then the legislature must write a new, technologically accurate law, rather than asking the courts to twist an old one beyond recognition.
And I maintain that until the legislature finally acts, we are left with a hollowed-out privacy protection. A law anchored solely to 1965 wire technology fundamentally fails to protect the right to privacy today.
A secret recording violates your privacy, it betrays your confidence, and captures your unauthorized words, whether it is recorded on a dictaphone, an extension line, or a Skype call. By clinging to the literal wire, we let the real threat, the unauthorized surveillance of our digital lives, fly right past us.
Well, it seems we are arriving at a point of convergence, even if we fundamentally disagree on the application of the current law.
I'd say so.
We both acknowledge that communication technology has vastly outpaced the original 1965 statute. The complexities of balancing our right to digital privacy against the aggressive pursuit of justice, especially in cases of severe digital exploitation, offers so much more to explore in the jurisprudence and the source material. We will leave it to our listeners to form their own conclusions regarding whether the rigid letter of the law or the broader spirit of privacy should guide the future of our digital communications.
Indeed. It brings us right back to that fortress. We have to decide if we are going to keep repairing the old stone walls, hoping they somehow stop an airplane, or if it is finally time to look up at the sky and build a completely new defense for the threats flying above us.
Thank you for joining us on the debate. Keep questioning, keep analyzing, and we will see you next time.